Welcome to the Sunmall podcast, where we interview the stars of e-commerce. Today we have Robert Freund, one of the most knowledgeable lawyers specializing in e-commerce and advertising. So the first question I had was, there's many different areas of the law. So how did you get into focusing on e-commerce advertising?
When I graduated from law school, I started working at a large firm called Greenberg Traurig. I was there for about 6.5 years. And a lot of the cases that we were defending were consumer class actions. And in California, especially, a lot of those cases have to do with some kind of false advertising claim, whether it's a pricing issue or a claim substantiation type of concept. I had a lot of exposure to helping companies defend those sorts of claims. When I decided that sticking around at a large law firm for the rest of my career is not what I wanted to do, I left in 2019 to open my own practice, and I wanted to focus more on helping entrepreneurs and established businesses avoid that kind of litigation in the first place. And we did some of that at Greenberg Traurig. We would have clients who would come to us to say, look, we're about to launch this new ad campaign, or we're going to release some new product. Can you take a look at the ad copy we're about to run, the way we're thinking of advertising this bundle or this promotion? Give us a risk assessment. Let us know if our competitors have done something similar and gotten in trouble for it, and then we as the business can make a risk tolerance decision about where on the riskiness spectrum we want to land. And doing that kind of work is more enjoyable for me. I prefer that to the litigation life.
Instead of helping merchants or advertisers after they've messed up, you try to help prevent that. One thing I've noticed is that you've started spreading a lot of these lessons through content creation over different social media channels. What's that journey been like?
Yeah, it's been surprisingly effective in terms of business development. And it turns out that it's something I enjoy doing. I was at a networking type event with someone that I knew, and I was explaining to him the type of work that I'm focusing on with my own practice. And I was talking about the social media aspects of compliance and working with influencers because that was the business that he was in. And he said, let me see what your Instagram looks like. And at the time, it was just a placeholder. I didn't have any content. I just had my name. And he said, if you are trying to get work related to social media legal issues, you need to have a better presence than this. Why don't you look at Tyler McBroom? I think he's got close to 1 million followers now. At the time, he had like 100,000. And what Tyler was doing then and still does now is he puts together quick, like 1-minute videos about common tax questions that he gets from his clients all the time. And it's engaging, it's quick, it's useful. And so I started doing that probably late 2019. And it got a pretty good initial response, and I was pretty consistent about posting at least a few times a week. And the combination of being consistent and then a healthy dash of luck propelled it. So one way or another, a couple pieces of my content caught the attention of pretty established people on social media. Back when verification meant something, they had big followings and were verified and reshared some of my stuff without me asking. I didn't even know these people. And when that happens, you get the attention of other people, and then they see, oh, people I know are following this guy, and it just builds its own momentum from there as long as you stick with it. 6 years ago, I never would have imagined that I'm in front of a camera in any capacity. It's not something that I set out wanting to do, but I do like it. The stuff that I post about is stuff that I'm reading to stay on top of issues for my clients anyway. So I'm already doing that work, and I might as well try to digest it. And the other thing about it is if you can teach something without looking at a script, that's a great indication that you know it, that you know what you're talking about. So it also just helps me stay fresh and make sure that I really do understand what I'm talking about as I try to stay on top of these issues. So it helps me in a number of ways, and hopefully it helps some people too.
That totally makes sense. I think a couple key points were one is it helps you relate and gain credibility with brands and stuff, right? Because you also have a social media presence, so you can relate it to it, and then also you have a way to make sure to clarify your thoughts and distill it and post it on social media. So let's move into some nitty gritty legal issues. So first thing is that as a brand, there's so many different legal issues. So is there some type of overall kind of framework or mental model I should use when just approaching my daily work?
I think it depends on so many factors what you should try to tackle first, and it also depends on what stage of your business you're in. So if you're starting out, if you're forming a new enterprise or getting involved in something new, starting with the fundamentals, have I set up a separate legal entity for whatever this project is? Or if I already have an entity, should this new aspect of it be under that, or should I set up a new structure that sort of silos that new piece of what I'm doing? Once I have that in place, if I have partners or if I'm working with other people from the get go, do I have an operating agreement that makes sense for what I'm doing now and what my goals are? Those sort of fundamental formational documents are so critical, and it's not the fun part. And I get, like, I understand people want to just get moving and start bringing things to market, but going back and trying to correct either mistakes or oversights once you've already gotten going is it's more expensive, number one, and it's just more complicated than if you have that sort of foundation laid at the outset. If you have all of that taken care of and the sort of structure of your business from a legal perspective is taken care of with the sort of basic documents, and if you have employees, you have employment agreements that are set up correctly, you think about brand protection. Have I trademarked the name that I'm going to be using? Have I made sure that I can trademark it? Have I done a basic clearance on that? Have I, for the assets that I'm using on my website, have I cleared the rights to that? Have I done the sort of basic steps to make sure that as I enter the market with this new plan, am I clear to do so? Or 2 years from now, is some other company that's arguably in my business vertical going to say, hey, you didn't own that in the first place, and then you have to figure out how to get out of that situation. And then it really depends on what line of work you're in and what your business does. There's different considerations depending on what business you're in terms of what legal frameworks apply. If you sell prescription drugs, that's a whole separate type of FDA framework you have to work within. If you're selling something that could be considered as security, you have SEC issues, things of that nature. The stuff that I focus on day to day is primarily FTC compliance, and that the FTC's rules about deceptive advertising apply no matter what business you're in. If you do anything consumer facing at all, there's going to be some standards about how you promote that business and how you conduct that business that implicates FTC compliance. In order to answer that question, you need to know, all right, what lane am I in? And then what considerations do I have to be aware of as I promote that business?
That totally makes sense. So I think it's important to get things set up from the get-go and have the basics there. And then obviously for specific issues, you have to do things correctly. Talking about company formation for brands, which do you recommend? I know there's like a Delaware C, there's LLCs. So what kind of makes the most sense for brands from what you've seen?
A lot of the answer to that question is driven by tax considerations. So I typically say that it's something that you want to sort out with your CPA in terms of, is this the only business that you have? Is this a subsidiary of something that you're doing? Is there some tax advantage that you could take advantage of if you choose one corporate structure over another? But generally speaking, the liability benefit or the liability protection, if you're talking about a C Corp versus an LLC, it's not very different. As long as you have that legal separation, that's the most important piece. There are some legal advantages in terms of where you incorporate or where you form the business. There are advantages to Delaware, like courts are much more familiar with the types of business disputes that typically come up if you're taking on investors or raising capital or things of that nature. And there's some streamlining benefits of setting yourself up there to take advantage of Delaware law, and similarly in different states depending on what you're doing. But a sort of broad strokes answer is it doesn't matter that much, and especially if you're just getting started and you don't think this is the kind of business that you're going to be raising a lot of money or issuing a lot of stock, at least not in the foreseeable future. A lot of times, just a single member LLC, if it's just you, makes the most sense starting out. It's simple, it's easy, and it can cover your needs. But it's not a decision that I would finalize until speaking with a tax professional.
That totally makes sense. That maybe some of the legal benefits are very similar rather than running it under your own name. But then there's also like some tax benefits. I know for an LLC, if you're making profit, you can not double tax it and stuff. But obviously, a tax professional will know best. I think one specific issue that I've seen on your content is how you talk about sales for businesses. So maybe you can talk more about that, some issues to be wary about.
Yeah, this topic has to do with if you're selling a product or a service and you're offering a discount promotion, or you're telling a consumer that, for a limited time, you can take advantage of this price as opposed to some former or original price. The reason I talk about that topic so much is because it's been the subject of a significant number of consumer class actions over the years, and it's not slowing down. It's like I have alerts set up for these sorts of things, and just today there's another big one filed against Amazon. But it's not just the Amazons of the world that have to deal with this issue. And there's an FTC rule about it, and then there are states that have their own pricing laws that you have to pay attention to, California in particular. The concept is you can't just inflate a price of something artificially for the purpose of marking it down to make it look like the customer's getting a bargain. The idea is if this coffee mug, if I say was $50, now 20, but I haven't really sold it for $50 for a significant amount of time in the not so distant past, then it's deceptive to say that you're getting a $30 savings if you buy it today. Even if you paid $20 for something that's worth 20, if you thought you're saving 30, the law treats that as a deceptive practice. The FTC's rule is kind of vague about it. It says if you're advertising something as a reference price with strike through or a was X type of anchor price, that has to be the bona fide price that the item was offered for sale for a reasonably substantial amount of time, which is like pretty loose language. California gets a bit more specific. It says an advertised former price has to have been the prevailing market price for that item for the majority of the preceding 3 months. So in other words, if I'm going to say this was $50, I need to have sold it or offered it for sale in good faith for at least 46 of the previous 90 days if I'm going to say that it was that price and now it's 20. And it's an issue that brands continue to find themselves in trouble for because it's so common still. Like a lot of marketers are surprised to learn this because tons of websites either are violating that rule or if they're not, it looks like they're doing that. And there's still just a flurry of class action activity about it, and the FTC is still, from time to time, brings cases about it. So it's one of those, it's not like the most important legal issue for a brand, I would say, but it gets so much attention recently on my social media because there's just been so much activity around it.
That totally makes sense. I had no idea about that until I saw that. And
Yeah, the other thing I would mention is a lot of times when I talk about consumer class actions like this, we might be talking about a product that $5 marked down to $2, and a question I get a lot is, who cares about $3 of liability? Can't I just refund the customer if they're not happy? But that is the trap with class actions. We're talking about potentially $3 in damages times every unit you've sold going back 3 or 4 years. So you might have a $5 product, and because you advertised it deceptively, the settlement value of a case like that or a potential judgment could be 8 figures, which has happened several times. So and you can't escape class action liability by just refunding whoever brings the case. That has been tried, and courts pretty much uniformly reject that strategy.
that
So
that
yeah,
I guess one thing is discounting is really common, right? Every brand is trying to do that. Obviously, I think you're saying is try to leave like 46 days out of 90 or something. Are there any other ways they can word it or package the discount? Maybe like a buy one get one free or something like that, or some bundling, any kind of tips there that maybe they can
Yeah,
try.
you can't get around a law like that by changing the wording. And because people have tried that too, the FTC's guides about that in many cases will say either using the word former price or similar language, or they'll even specifically list like if you use this word or any of these synonyms, we're talking about the same thing. There are ways to always have some kind of promotion going on as long as you vary what the nature of that promotion is. So I can't, like taking the mug example again, I can't have a Mother's Day sale that then goes directly into a summer sale that then goes directly into back to school or something if I consistently say that advertise that former price and that's never the price for long enough. But I could run that sale for 2 weeks and then restore it to that original price and then discount something else. Or maybe then do offer a bundle and save type offer or a buy one get one or something like that. The buy one get ones though actually have their own specific FTC rule about using the word free. There's a separate section of the FTC's guides that talks about using the word free. And the rule there is if you're going to advertise something as being free or bonus, if you buy one product, you get this other thing for free. It's deceptive to say that unless you separately sell that item for whatever price you're saying its value was. So there's a case before the National Advertising Division, which is a voluntary process, but if you don't comply with that, it can be referred to the FTC. Without getting into the woods of it, or into the weeds, there was a mattress company that was offering a promotion that said every mattress includes 2 free pillows valued at $50. But the problem was they never sold those pillows for $50. So the idea is I'm not actually getting that for free. That's the price of the mattress. It's always free. I can never actually buy that for $50. So it's deceptive to say that I'm getting something extra when really that's just the price of the item that I'm buying in the first place. There's less. I haven't seen any case where that's the only issue, where somebody tries to bring a class action or an FTC enforcement action just because someone is using buy one get one free or something. Doesn't mean it's not out there. It just more commonly I see that as part of there's a cluster of practices that are being challenged. One of them is, oh, buy this course and get a bonus notebook, when the notebook is always free and it's not really a bonus and it's not $100 value or something like that.
That totally makes sense. So people are catching on all these kind of different ways to discount. So what I'm getting is that you basically, it doesn't matter if you do a buy one get one free or 50% off. You can't really offer the same type of, or any type of discount on the same product consistently. You always have to do whatever 46 days out of the 90. But you do is maybe have sale on SKU one, and then turn that off for a bit and go to some type of discount on SKU two, and rotate that way. So
Right.
what is the small, maybe like even the mom and pop store might get scared and stuff like that. So what is the smallest brand you've seen been litigated so far? Of what revenue? Obviously it depends, but has there been a smallest revenue size seen litigated so far?
Yeah, I mean, it depends on the claim. Like there are some claims where the plaintiff's lawyers don't care about the size of your business at all. The TCPA, when that was a more popular claim to bring over SMS or junk faxes in particular, those lawyers just they'll file 100 of them in a day, and they're not checking revenue figures or whatever because the business model for that type of claim, if you're that lawyer, is I know that I'll probably settle every one of these for $5,000 because it's going to cost someone at least that to hire a lawyer and challenge it. So if I file 100 of those a day, I could potentially make $500,000 every single day by just spamming out TCPA lawsuits. ADA website violations are today's version of that, even though those have been trimmed a little bit. And it's the same thing. I don't care the size of your business. You have a website. It's not accessible to people with a visual disability. Surprise, you're being sued. If you want it to go away, it'll be somewhere between 5 and 15 grand probably. And they'll just do that every day you could have no revenue, and maybe that makes the value lower, or maybe that will convince them to go away. But for claims like that, where the plaintiff's business model is just spam them out, it does not matter what size you are for a lot of those attorneys. For things like claim substantiation or pricing, it also just depends. There are some firms where they are sophisticated enough where they're only interested in like the Amazons of the world, and going after really big companies because they're set up to handle that kind of litigation and take it all the way. And they want the huge settlements like the ones that I post about, like the Boohoo settlement. That company just agreed to a $197 million settlement over the pricing issue we were talking about. So those more sophisticated plaintiffs firms are not going to go after a mom and pop shop, but there are some that will, or will at least send you a demand letter about it, because maybe they're not set up to handle that kind of massive litigation all the way. And they're going to make their money by sending out demand letters to every e-commerce shop they can find, and they're happy to settle for much, much less. So all of that is to say there's not really like an income threshold below which you're not going to be a target. And that's a comment and a question that I get a lot. And there's a popular belief that if I fly under the radar, if I'm under 10 million annual revenue, I'm not going to be picked up by the FTC. That might be true. The FTC has gone after small companies too. Certainly the larger you get, the more customer complaints you're going to get, probably, right or wrong. And the more likely it is that a federal agency will pay attention. But they're not the only ones you have to worry about. There's state regulators, there's consumers, like I mentioned, there's your competitors, and so on. So, yeah, if you could quantify the risk, it's probably slightly less likely that you would be a target if you're a small company, but by no means a guarantee that you're safe.
That totally makes sense. So there's obviously types of lawsuits where the firm might be actually trying to win, and so the more revenue you make, the better. But there also might be ones where they don't even care if they win; they just want you to settle, and so they're just going to send out as many of these as possible. One issue you mentioned the Disability Act kind of stuff. So are there common things you see on people's websites where they violate this, or any kind of key tips there?
Yeah, this is a frustrating one. I can't claim to be an expert on defending these. If you are in a situation where you've been sued for this, I know someone who focuses a lot of their practice on it. But it's difficult because the law that is being deployed, the Americans with Disabilities Act, doesn't specify like this is exactly what your website needs to have in order for you to be compliant. Instead, there's sort of an industry standard. It's called WCAG. I think the standard that most courts have adopted as being reasonable, I think it's called WCAG 2.0 AA. There's varying levels of website accessibility scores that are available to you. And what you can do is you can hire their consulting firms or business services that will audit your website, tell you what you're missing. Does the text to speech work correctly? Is the screen reader compatible? And things like that. And get your website into compliance with that industry standard. That doesn't necessarily mean that you'll fend off a lawsuit from these lawyers, some of them that are just spamming out demand letters. They should be checking to see if you're compliant or not. Not all of them are. And it's not always clear, like, you can go through a checklist and say, I 100% for sure am not subject to this law. It's still going to be the burden is on you to no, you don't have a claim here. I am compliant. I've hired this service to get me in compliance and have that discussion. But the advice that I give is have someone who knows how to do that kind of audit look at your website and bring you into compliance if you want to avoid having that happen. It's so common, though. It's almost at this point rare that I have a client who hasn't at least gotten a demand letter from an ADA attorney.
That totally makes sense. So use some service, maybe some automated tools to do the automated check. It's like just for these like lawyers who just send it in bulk. You'll probably still get it because they just spam it and then just a lot of times hope for the best. So maybe quickly, like when you get some of these demand letters, like maybe sometimes you should hire a lawyer, but what are some other alternatives? Like let's say I know yeah, I did this audit. Now I got this thing. Maybe I don't want to hire a lawyer and spend all those fees. Or is there some quick ways I can, like, what do I do next?
Yeah, I think that it's always a good idea, and I truly am not just saying this because out of self-interest. It's always a good idea to have an attorney look at a demand letter before you respond. That lawyer might say, "I don't. You don't need a response on my firm letterhead. You can write back and say X, Y, and Z." But you don't want to be in a situation where you have misinterpreted something that's in that demand, and your response inadvertently either gives that lawyer an inkling that there's more there or encourages them to take a closer look or somehow gives your opponent an advantage unintentionally. So I think it's always worthwhile to have an attorney spend, it could just be an hour if it's a situation like one of these ADA demands. They're usually not very long. You can probably have a consultation with one of these defense attorneys who will at least give you direction and say, yeah, if you are certain or at least comfortable saying that you're compliant because you've done X, Y, and Z, write back to those people and let them know. Sometimes it's in your interest to have that response come from a reputable firm to send a message to that plaintiff's lawyer that this is not going to be easy, it's not going to be a quick settlement, and we've established that your claim is frivolous, and if you go forward with it, you could be sanctioned, and so on. I think the bright line rule is don't ignore demand letters. That's a common mistake I see. I'll sometimes hear from people who say, I got this letter in the mail, I thought it was bullshit, I figured they wouldn't file on it and it would go away. Usually it doesn't. Most firms that are going to send you a demand, especially for something like a copyright infringement claim or one of these ADA things or something like that, they are going to follow up with a lawsuit if you ignore them. And at that point, it's almost always more expensive to get out of than if there was a way to get out of it if you hadn't ignored it. So I recommend always having, if you get any kind of litigation related threat from a lawyer, have counsel at least take a look at it and give you some options for what to do about it.
That totally makes sense that these letters, don't ignore them. And maybe if you just do it properly, it'll save you money in the long run. And if you've really had all the ducks in a row, even the consultation or getting the letter drafted, the response can be pretty quick. So one thing I've seen is, and I think this was on your channel too, is AI is getting a lot of hype these days with GPT and a lot of this stuff. So a lot of people are interested in having chatbots on their site. So any kind of tips there when implementing those solutions in the legal sphere?
Yeah, the chatbot thing is interesting. And what I was writing about recently is there's there's a law in California that it has to do with wiretapping and eavesdropping on conversations. For a bit of context, the law initially was designed to prevent people from snooping on telephone conversations without people realizing that there was some other third party listening in or that the other person on the other end of the line was recording your call if you thought it was going to be private, which is a great policy. Like, that makes total sense. There have been at least 70 lawsuits filed in the last 12 months trying to shoehorn or trying to apply that law to say that the use of chatbots that store conversations with users violates that wiretapping law if the user is using a mobile phone in their mobile browser to interact with the chatbot. The argument is this law allows for, as long as one person's on a mobile phone, if a conversation or communication is recorded or shared with a third party without that phone user's knowledge and consent, then you're violating this law. The damages potentially available are, this is under the statute, you don't have to prove them. It's $5,000 per violation. So if you have 100, only 100 people interacting with your chatbot in California, you potentially have a $500,000 exposure if this theory works. The state of these cases is that they are recent, so we don't have that many rulings from the courts about whether that theory works or not. The rulings we do have, at least from California, are conflicting. Some judges say that is not what this law was intended for. We can go back through the drafting history. We can go back through similar, or at least as analogous as we can get situations. And this is, you're warping this beyond what it was intended to do. But at least one judge is consistently saying, that's what the statute is written as. I'm going to apply it the way I think it's written, and these claims can go forward. So right now, it's a risky thing to have a chatbot on your website until we get clarity, which will probably take months at a minimum from the courts as to whether this is actually something that carries exposure and is a legally tenable theory. So I don't know that I would necessarily say delete all chatbot functionality from your website. One thing you could do is just have, I'm not a back-end guy, I don't know if this is feasible for certain software, but if you had something that allowed people to check, hey, when you interact with our chatbot, we keep the logs and we might share it with our partners, or something that gives people notice that it's being recorded, then that's, you can't really eavesdrop on somebody when they know that you're there. So that's one potential way to deal with it. It's interesting because it's not like there's an articulated rule where I can just say this is the law and this is what courts say. It's developing right now.
That totally makes sense. The law, the cases have to play out, so like precedent and rules are established. But at your point is you can maybe buy chatbots or whatever solution you implement. Just make sure they have a good disclaimer in place before you go there. One thing that's been really big right now is using UGC and stuff like that on your website to really establish credibility. So what are some things to watch out there for?
Yeah, there's a lot of potential traps or landmines you can step on with UGC. The most common one that I see brands get in disputes about is simply rights clearance with that content. So making sure that you have something in writing that allows you to use that content in the way that you want to. So, for example, like if you are doing an influencer campaign, you want to make sure that your agreement reflects what you have in mind for what you're going to do with that content and the influencer. And an example that came up not too long ago is pretty typical. A brand sent some free product to an influencer in exchange for that creator posting one Instagram reel to the creator's own page. And that was the deal. At least that's what the influencer thought the deal was. The brand thought, okay, since we've paid for that piece of content, we can take it and run a YouTube ad behind it. But you can't do that unless you have an agreement that says you can. And in that situation, by exceeding the scope of the usage license, the brand has a copyright infringement problem and a publicity rights problem on their hands. So you want to make sure that anytime that you have a connection with some content creator, or you're going to use some content that you did not produce in-house, that you've both cleared the rights to use that content in terms of the copyright aspect, and if that UGC includes someone's face or name or even their voice, you want to make sure that you also have the right to, you've cleared the publicity rights to it. It's two aspects of liability that come up pretty commonly if brands don't have that cleared. And another way that comes up is a common misconception from the brand's perspective is that, let's say I make shoes or something, and there's a customer out there that I don't have any connection to, but I see that they posted on their Instagram page them wearing the shoes, and they've tagged my brand in the post, and they talk about how much they love them. Some marketers assume that if a user tags a brand in a post, that means that I can repost it on the brand's page. But you can't, and it's for the same reason that we just discussed. Tagging doesn't assign or give a license to any rights or transfer any rights in that content at all. You do need to make sure that you do that rights clearance with every piece of content that you use as a brand, because everything that's on your brand's social media pages or your website, all of that will be treated as your brand's advertising, and so you have to do that rights clearance.
So for the rights clearance, do I always have to send them a form and they always have to sign it, or is there any other way? Like, can I do something with commenting? Please comment if you clear the rights, or how exactly do I get that rights clearance?
Yeah, the most buttoned up way to do it is to have some kind of quick form that you can keep somewhere that shows, okay, this is what we agreed to. It was in a separate document. It's not always strictly necessary. If you see a piece of content on someone's page that you like and you send them a DM that says, hey, we'd like to repost this on our Instagram page. We'd like to keep it up for 30 days. If that's okay with you, write back yes. And they write back yes. You're pretty much covered in that situation. You just want to be sure, again, that you've set out how you're going to use it and for how long, and that's all you do with it so that there's not some issue down the road.
That totally makes sense. Last issue here is I've seen a lot of things with reviews and repurposing reviews on like different SKU levels, different product levels. So maybe you can comment on that.
Yeah, reviews is an area that it would be boring, but we could spend like a couple hours doing it because there's a renewed focus that the FTC has with the way that advertisers use customer reviews. And they have said over and over again that this is going to be a focus. They're undergoing a process by which they're considering making new rules about it. And it has to do with the issues have to do with using fake reviews. If you're just making up reviews, I think most people would know that's probably not something that's kosher to do. If you display reviews on your brand's website, you want to make sure that you're not only showing the 5-star and suppressing the lower ones, including the order in which they're presented. There's a pretty big case from the FTC from last year over exactly that. There's a big retailer that wasn't showing all of the reviews equally. So they were either only showing the 5 stars on their site, or they made it much more difficult to actually see the 2-star and 1-star reviews. And then soliciting reviews. If you are paying someone or giving someone an incentive or some kind of benefit in exchange for a review, even if you don't say your review must be positive, that review needs to convey to the public that it was paid for. So if you do something, it's pretty common for brands to give out free product in advance of the launch of a product so that when it goes live, they've already got the social proof of like 100 reviews. But if all those people were given the product for free, the FTC would tell you that needs to be made clear to the public, or else because that would affect the weight or credibility that a consumer would give to that endorsement. Like maybe I would want to know that everybody who loved this mug got it for free or were friends of the founder or something like that before I decided to pay for it. I think one of the issues that you were referencing was there's an FTC case about review hijacking on Amazon where a seller of supplements basically they had amassed a lot of great reviews for one SKU, but then swapped out the Amazon listing or related a different product to that original listing so that it looks like all those reviews are talking about more than one product when the products are very different. And basically the takeaway from that is if you're going to relate products under the same Amazon listing so that you share reviews across them, the differences between those related products, it has to be something like 12 pack instead of 24 pack, or like red shirt instead of blue shirt. It can't be zinc supplement versus weight loss pill or something. That was a rapid fire of a lot of the review issues, but I think it indicates that it's more than just am I faking reviews or not. There's nuance and there's regulators are looking at it with more particularity than you might expect.
That totally makes sense. There's a wide variety of issues there. Last couple questions here. If a brand wants to engage with you, how do they engage with you? What kind of services do you offer?
Yeah, so the easiest way to find me is I'm active on Instagram and on Twitter. I try to post stuff relevant to the things we've been talking about and new developments. If you want to work with me, my website is robertfreundlaw.com. You can book a consultation there. The nature of how it works depends on what the client's looking for. Sometimes it's, hey, I need a master services agreement. I'm a marketer, I'm an agency, and I want something that I can always present to brands that's more or less the same. Or I got this red line document back. can we just look over this? For sort of discrete projects, we can usually do flat fees. Everything else is typically hourly, but I try to be flexible where I can. My my area of focus is the stuff we've been talking about. It's compliance with consumer protection laws. If you're bringing a new product to market, or if you just want to say, I want to make sure that I at least understand what rules apply to me, where the areas of risk might be, so that at least then I can know the rules of the game that I'm playing and then decide how much risk I'm comfortable with as a brand. So I do that pretty commonly, where a client would say, look through our website, identify the issues, identify what you think the risks are, and I'll try to, rather than just say, this is risky, don't do it, come up with an alternative that brings you, if not in full compliance, closer to it, and then you can decide what you're comfortable with. So that's sort of like compliance auditing, and then any contractual drafting related to advertising and marketing specifically, but also any independent contractors or vendors, things of that nature, and then the more general outside counsel or outside GC type work. So if you do need to set up an entity in California, or your operating agreement needs updating, or you need to sell equity to somebody, or the sort of general operational business legal issues, we handle that as well.
And that totally makes sense. So a wide variety of stuff, but especially helping brands think through some of the trade-offs when implementing stuff and the different risks there. Totally. And then one last quick one. Is there a recent brand you bought or shopped that you were really impressed or really enjoyed the experience of?
That is a good question. The purchase I'm most recently happy with, I was in the market for a new laptop. I had been using a Microsoft Surface Book. It was like 7 years old, and to its credit, like, it was still trucking along, but the webcam was trash, and the screen was too small for my liking. I just got this HP Envy, and I love it. It's super powerful. I think this webcam is decent for a laptop. Nice big screen, no complaints. So shout out HP for the.
Thanks for listening to this episode of the Son Mahal Podcast. Please make sure to subscribe.